Now, this is a fascinating judgment where a party sought immediate division of a joint estate under Section 20 of the Matrimonial Property Act. In other words, I don't want to wait to be divorced to divide the joint estate immediately. There was a dispute on whether the marriage, these were two non-South African original citizens, if I can put it that. They were not from South Africa originally. And there was a dispute on whether the matter should be heard in terms of Turkish or Romanian law. The applicant launched an application for immediate division of the joint estate. And the court looked at a few interesting factors. The court looked at lex domicilii matrimoniae, the place of domicile of the marriage, which country's legal system applies to it. In terms of South Africa, in our courts, it still is followed quite universally that it follows the husband at the time of the marriage. That brings along with it, obviously, its own set of problems, but that's a discussion for another day. The court looked at Section 20 of the MPA, and then procedurally, the court also looked at the principle of making a case in reply and not complying with Rule 36.9 in terms of expert evidence. The court said, in my view, the underlying principles of lex domicilii matrimoniae remain the same. The MPA forms part of South African law. It does not apply to foreign marriages unless expressly provided for by way of ANC, as South African law is not the lex causa of such marriages. Application obviously did not succeed the application for immediate division of the joint estate. This was in the context of a Rule 30 application. Hell of a judgment to read. It's quite a nice judgment in terms of a very, very broad discussion. It's about 17 pages. It's not too onerous. Well worth a read if you do decide to get the case law bundle. As I mentioned, this judgment particularly not yet available on Safley.